Who qualifies for adjustment of status in the United States? That is the process of applying for permanent residence while you stay in the United States, as in you don't have to leave. I am U.S. immigration attorney Sharifa Tharpe. I help clients to get their green cards and status in the United States. Now, this is what I want you to know. Not everyone who qualifies for the green card is going to qualify for adjustment of status. So it's important for you to know whether you qualify or whether you're going to have to follow a different path. So I'm going to explain to you certain who qualifies for adjustment of status. So one is if you're in the United States, you're applying for permanent residence and you're maintaining your legal status in the United States, then it is likely that if you can maintain that status for the entire time that you're applying for the green card, you can qualify for adjustment of status. So for example, if you're here on an employment-based visa, such as an H-1B, and your H-1B is 6 years, for example, and the process of getting the green card is going to take 5 years, adjustment of status may very well be possible, because by the time you get to the end of your process, you will be able to, at the green card process, you'll be able to adjust status while you're still on the H-1B. Now, if you're here on a B1 or a B2, it's going to be different, because remember that you have to have temporary intent. So you can't be here and continue to maintain a B status, a B1 or 2 status, and complete the green card process here. First, that would be contradictory. And second of all, green card processes right now is taking, so the adjustment of status process is taking a minimum of 2 years. So you would have to maintain your B1 or B2 status, that's a visitor's visa status, and it's a temporary status, for 2 years, but you likely would not be able to do that, just because the maximum time that you get every time that you enter the United States is a maximum of 6 months, and you're lucky if you get 6 months, right? You could apply for an extension, but being able to continue to apply for an extension in order to apply for permanent residence, it's very unlikely that you would be approved, because those two intentions are contradictory. Coming into the United States on a B1, B2, extending your status for temporary purposes, but then applying at the same time for permanent residence. And so in this case, it would not be possible to be able to be here on a B1 and adjust status at the same time. And furthermore, the B1 or B2 status is not going to be likely to last as long as the adjustment of status. And so in a case like that, you would have to look at whether you qualify for an exception to the rule, where you can apply for permanent residence even though you possibly overstay your visa. For example, I'm going to tell you a few of those categories that qualify for adjustment of status despite a visa overstay, even if you cross the border without permission. And so the first is, are you the immediate relative of a U.S. citizen? Because if you are, then there is a possibility that you could still stay in the United States and apply for permanent residence. But you would have had to come into the country with some sort of permission, you would have had to be paroled into the country, inspected at the border in order to qualify. Now, it doesn't mean being inspected at the border doesn't mean that you have to be in status, but you have to show that in the past, when you entered the United States, you did it legally through some sort of permission. If you can't show that, you're gonna fall into a different category, and you'll have to find a different way to get permanent residence. And I'll explain that way briefly today. But if you're the immediate relative of a U.S. citizen who came into the country with inspection or permission, then adjustment of status is a possibility as long as there are no other disqualifying factors. And even if there are waivers available. So for example, if you have a criminal record and you're inadmissible, qualifying for adjustment of status could possibly mean that you could apply for that waiver. But that's a whole new topic for a different time. My rule of thumb is if you do have issues like criminal issues, make sure you schedule a consultation. But right now, I'm going to stay on track with adjustment of status. Who qualifies for it? So that was it. The immediate relatives of U.S. citizens who came in with some sort of permission. Now, the other category is, are you being mistreated, or are you being subjected to extreme cruelty or abuse by certain relatives, a U.S. citizen or legal permanent resident, spouse, or parent? With a parent, you have to be under 21, or if there was a delay and you're now over 21 but under 25, and the mistreatment or abuse caused that delay in your application, then you could be under 25 and still apply for this form of relief. Also, if you're being mistreated by a U.S. citizen's son or daughter who's 21 and up, then you could possibly qualify for adjustment of status through VAWA. So this is Violence Against Women's Act, but keep in mind that even though it's named the Violence Against Women's Act, it's for everyone. It's for children, parents, men, women. If you are being subjected to severe mistreatment, to extreme cruelty or abuse, doesn't have to only be physical, then you should schedule a consultation and let's talk more about this. And you can always call this number, or go to the website where you will be able to get in touch with a scheduling coordinator to get on my schedule and evaluate your options. But right now I'm telling you that under VAWA, even if you came into the country without permission, snuck across the border, you could qualify for this form of relief in certain cases. Even if you overstayed, you could qualify for VAWA, and VAWA allows you to do adjustment of status to get your permanent residence, and you get a work permit in the meantime. So that is one of them. Now, if you are a T visa, so victim of trafficking, or a U visa, victim of crimes, and you have received these, so you are a U or T visa holder, then you could possibly adjust status if you have had your U visa or T visa for 3 years out of the 4 years that you're allowed to have it and work in the United States. Now, the journey to adjustment of status through the U or the T visa is first going to determine whether you qualify for the U or the T visa. If you've been the victim of certain qualifying crimes, so if you have been the victim of crimes that have resulted in severe mental or physical abuse, then this could be for you. So for example, have you been subjected to domestic violence? Have you been subjected to assault, robbery, fraud in certain cases? Fraud can definitely impact your mental state, and so that could be a qualifying crime. My rule of thumb is if you have been the victim of a crime, see if you could qualify under the U visa. And keep in mind that applying for the U visa could get you your work permit even before you get to adjustment of status. So you could, once you submit, it's called a U visa certification. So once you've been the victim of a crime and you submit to the law enforcement, you request a U visa certification. That's what I do for my clients. Once we get the U visa certification, submit the relevant documentation, as well as to do the biometrics, so fingerprinting appointment, and they determine that your application was properly filed and you meet those requirements, you could get a work permit while you wait for the U visa to be approved, or you wait for a decision on it. The T visa, my rule of thumb here is that if you came to the United States, if you were lured to the United States, and when you came here, you were forced to do things that you didn't want to do, or you were mistreated or abused by your employer or by an individual who sexually abused you or subjected you to sex trafficking, then this could be a path for you as well. So this involves labor as well as sex trafficking. So schedule a consultation. I can definitely evaluate whether you could qualify for this. and then if you qualify for it, it could eventually lead to adjustment of status in the United States. That means a green card eventually and a path to citizenship. And then the last path to adjustment of status, especially if you're out of status, is asylum. So if you have a fear of returning to your country because you are a part of a particular social group that is being harmed in some way, being threatened, harmed, killed, abused, these are examples of persecution. If you are afraid of this in your country, then you could possibly qualify for asylum. And asylum could lead to a work permit, but most importantly, if you are approved for asylum, after a year of being here on asylum, you could adjust status to permanent residence. So those are some of the exceptions to the rules that you have to maintain legal status in the United States. What are the benefits of adjustmental status should you qualify? So the first is you can get a work permit while you're applying for adjustmental status. That does offer some relief and comfort while you wait for a decision on your application. There's also the possibility of getting the travel document. If you've been separated from family, you would be able to travel on that travel document to visit your family in your home country. And in addition to that, you get to stay in the United States, as I said before. That is very convenient. So you don't have to have that fear of leaving the United States and getting stuck outside of the United States to complete the green card process. Now, if you don't qualify for adjustment of status, what are your options then? So in this case, it's really going to depend on your particular circumstances. Usually, if you don't qualify for adjustment of status, that means that consular processing, finishing the process in your home country or in a country or consulate of your choosing is going to be that other option. However, many undocumented individuals are at a point where they're at a point of no return. They've overstayed over 180 days. And if you overstay over 180 days and you set foot outside of the United States, you're barred from coming back for at least 3 years. That means no green card, no visa, no re-entry into the United States. You're inadmissible, banned from the US for those 3 years. If you've overstayed over a year, that turns into a 10-year bar. And so you're between a rock and a hard place. If you even qualify for permanent residence, but you're already in the United States and you've already overstayed and accrued unlawful presence, that means you've overstayed over the 180 days, you can't leave to finish your process. However, there is the process of the I-601A waiver or provisional unlawful presence waiver, and it is in place to try to help to solve this problem for so many individuals. So to qualify for this, though, you will need to have a qualifying relative. So you'll have to have a US citizen or legal permanent resident spouse or parent who will experience extreme hardship if you don't get the green card. And so one thing I like to say is don't underestimate this process. If anything I'm saying here is at all familiar, get legal representation to get you through this waiver process. But essentially what this waiver does is it allows you to stay in the country, wait for a decision on your waiver. And once you get an approval on your waiver, you're able to leave to attend the interview in your home country or a country of your choosing. And when you attend that interview, that unlawful presence or the overstay would not be held against you. You would be forgiven based on the waiver. And as long as there are no other disqualifying issues in your case, you would be able to go to the consulate or the embassy, attend your interview, all being well, get approved for your immigrant visa and come right back to be with family again. Now, this is why it's important to get representation, because preparation of this to show the extreme hardships of your spouse or your parent is hard work. It takes legal know-how, coordination, and strategy, because it has to be effectively communicated to the officer for them to understand why these amount to extreme hardship for your qualifying relative. Another thing is that you want to have your case fully evaluated to determine that this waiver will work. Because if you have other inadmissibilities, for example, if you're inadmissible because of a past criminal issue, if you're inadmissible because of another type of immigration violation, such as misrepresentation or fraud, then this unlawful presence waiver would not be able to assist you, because if you leave the country, it only forgives the unlawful presence. It doesn't forgive other forms of inadmissibilities. So you would get a nasty surprise going to the embassy if you do have other issues. So it's very important you get representation and an advocate throughout this process. So that's all I have for you today. Who qualifies for adjustmental status? I answered this, and also alternatives. I could spend another half an hour on the waiver process, but I'm going to save that for another video. So I'll see you again soon. Have a good one, guys.